So good afternoon and welcome to this Governors for Schools webinar. Thank you for joining us. My name is Oliver Keane. I put together the Governors for Schools webinar programme. Today we're joined by Jenny Arrowsmith of Irwin Mitchell for a session on strategic HR. Jenny will be answering questions at the end of the presentation, and you can send these through using the questions box on your webinar panel. Without any further delay, I'll hand over to Jenny and catch up with you at the end of the session.
Hi, thank you. I was just trying to put on my webcam so you can see a face, because I always think it's nicer when you can see a face, but I actually can't see my slides when I've got this on, so I'm just going to turn my webcam off. But hello, I'm Jenny Arrowsmith, an employment partner in Irwin Mitchell. Irwin Mitchell are a full service firm. We work with all sorts of clients from different sectors, but I particularly look after the education sector with a specialist area of schools. So the kind of things I'm going to be talking about today are just things that I've seen from working with schools over many months and years, but increasingly at the moment, these are really the pressure points, I think, and the kind of things that we're being asked to advise on a lot. So I thought this session would be useful for you as governors and leaders within the schools and multi-academy trusts, just to understand some of these issues. And what I'm hoping is it'll just be a takeaway for you so that you got a grasp of the issues and then you know what to be talking about at that leadership level. I'm not going to try and cover everything in a huge amount of detail. There's a number of topics that I'm going to be covering, each of which can be quite complex. So it's at a high level, and hopefully it'll give you some good food for thought. Please do ask questions as we go through. I'll try my very best to pick those questions up as we're going through towards the end. I'll hopefully have a bit of time. If not, if you've left your details and your email address and you've got a specific question, I'll do my very best over the next few days to come back to you and address that directly. I think there'll be a feedback form as well at the end of the presentation, which Oliver will be picking up. And I'd be really grateful if you would fill that in. We're doing a number of these webinars with Governors for Schools on a variety of topics, employment law being just one of them. And we'd be really interested to know how you find them and what kind of information would be valuable to you, and we'd be more than happy to support. So I'm just going to take you off webcam and then we will move on to the presentation. Okay, so we're talking about strategic HR today. So what does that mean? Well, I think when you're looking at strategic HR, there's a few areas, and I've tried to summarise those on the screen. I know that you're all, whether you're large or small, you're all dealing with very constrained budgets. And as academies grow into multi-academy trusts, multi-academy trusts grow larger and larger, the scope for efficiencies increases. But you've always got to be looking at how efficient you can be in your management of those of your staff, and staff obviously is the biggest spend in terms of your budget. So when you're looking at strategic HR, it's not just dealing with the the ad hoc disciplinaries or the performance management and how you manage absence. Don't get me wrong, they're incredibly important, and if you get those wrong, not only does it add to cost, but it adds to unnecessary management time as well. But it's stepping back and thinking, well, how else can we do things differently? Where can we reduce costs to make those savings that we necessarily need to tackle a deficit budget or avoid getting into one? How can we get the most out of our arrangements to maximise efficiency? And what do we need to be doing to set ourselves up for growth? And that's in particular where you are a growing mat. And a lot of this comes down to challenging the status quo. So not just accepting the same roles for the sake of keeping things the same, not just recruiting into vacancies just because they've arisen and that's what you've always done, have that post. Thinking, what do we need and why? And also, and the focus of today's session is looking at the terms on which you engage people. As academy trusts, you are not bound to incorporate the traditional teacher terms and conditions and support staff terms and conditions, albeit I know a lot of trusts do, but many don't. And one thing I particularly want to highlight today is just the opportunities or the particular costs that you necessarily inherit if you do incorporate those terms. I understand very clearly the pressures that you are under to ensure that you are an employer who is attractive to skill and talent out there, and that there is an expectation in the market that you will offer terms that are consistent largely with what might traditionally been offered under those terms and conditions. But I think there are still some things that can be done to the benefit of your trust, and hopefully that will come out in this presentation. But like I say, in terms of reducing costs, it extends not just to that, but looking at restructures, which I'm not going to tackle today, but is likely to be something that you may well be having to look at in due course. I'm quite often involved very heavily with schools at this time of year and in the spring term, and looking at restructures to get things in place for September. And that isn't just to reduce cost, it is to make the most of the arrangements and ensure that you've got what you need in place to have the right leadership, have the right office administration structures, have the right people in place for your learning and development, and ensuring the best outcome for the school for the benefit of the kids. So there's a lot to it, and I'm just going to focus in particular on some contract points. Why? Well, there's been some legal updates of real importance lately, some of which are case law, some of which have come through from statutory updates, and these affect all sectors, but are something that you particularly do need to be looking at. And my own feeling is that perhaps not all schools are looking at these issues and should. So I'm just going to spend the first bit of this session looking at some of those areas. Then I'll go on to talk about some of my observations in relation to some of these inherited terms, if you do incorporate terms and conditions from Burgundy Book, Green Book, and School Teachers Terms and Conditions document. And then, time permitting, I'm just going to do a quick wrap up on where we're at with COVID as well. So you're hopefully all aware, and hopefully have already ensured that your standard templates for the people that you engage, whether they be workers or employees, are updated, because from the 6th of April this year, the law changed so that there's always been a requirement that a standard contract of employment would include certain provisions, but the level of information required has increased. And whereas before you had up to 2 months to provide that information, and it was quite standard, I think, in the sector that offers would be made and a contract would follow much later, that's no longer acceptable. These contracts and statements need to be provided from day one. And also the extension is it applies to workers as well as employees. So that could include people like your invigilators and people that you work a bit more casually. So as a starting point, your contract templates for new staff need updating. It's not a massive job, but it's an essential job, because if you don't have an up-to-date and accurate Section 1 statement, as we call them, then there is a potential liability of 2 to 4 weeks pay, which obviously, if you look at that across the whole of your workforce, you absolutely don't want to be in that situation. It's called a Section 1 statement because that's just derived from the piece of legislation where this list prevails, but ultimately that this information is normally embodied within an employment contract. We're at a time in the academic year where lots of offers are being made, notwithstanding COVID, for new jobs starting in September. So please make sure that any contracts that you are sending out are compliant. It's also important to note that this statutory update also applies to existing staff. Now, you don't have to be issuing new contracts to existing staff, and please don't go ahead doing that, because there's certain procedures in relation to that. You've got to be careful where there will be any amendments. But an existing employee does have the right to request one of these updated statements, and if they do request, you've got a month to respond. So my advice to my school clients is not only get your updated template for new recruits sorted, look at your existing template and ensure that you have the right information that you can then provide. And it's really key to note that some of this information has to be provided in one document and some can be provided in a separate document. But if I take holiday as an example, many contracts I see don't adequately deal with holiday, or at least to the extent that we would recommend to cover off some of the things that crop up, and holiday is a particularly problematic area at the moment, but also not to be sufficiently detailed to be compliant with the Section 1 requirement. So to that end, I think it's important that you're updating your current templates as well, so that if an individual does ask for this updated statement, you've got the information, you can send it really easily, and you can send it as part of that same that document. At the same time, what I'm recommending, and I'd recommend to you, is that you get a review of those templates that you're using, both for new staff and current staff, and just have an eye on, well, what must be changed and what is recommended to be changed. And much of what I'm going to go on to look at is recommended, or things for you to think about. But this point in particular is a must do. You need to do it in order to be statutory compliant. Like I say, it's not a massive job, but the kind of information that you now need to provide not only is about who the employer is, the place of work, and the arrangements for sick pay and holiday. It needs to be sufficient information so that they can calculate their holiday accrual, calculate the way in which they'll get paid in relation to that, understand what training will be provided to them and the extent to which that's compulsory training that they must undertake and voluntary training, and also set out what paid leave they're entitled to. So that would be maternity, paternity, and other types of leave. That there also needs to be reference within that, and details of how they can access further information. So that's just one thing to check that you are covered off with. At the same time, and linked to this point about paid leave, I just wanted to put this point in just to let you know, if you don't already, that there is now a right to bereavement leave. That came in on the 6th of April. And ultimately that right gives parents up to 2 weeks leave if their child dies, if their child is under the age of 18 or they have a stillbirth. That doesn't need to be dealt with in great detail in the contract, but reference obviously does need to be made, and more particularly you need to have a policy in relation to that added to your other paid leave policies. So I just add that in as an aside, really. There are a few things coming through therefore on case law that I think, whilst you're looking at this, would be worth you thinking about, and this is one of them. So there's a case, not an education case, but the principle very much applies, where an individual was issued with notice of termination. It was absolutely key that she received notice of termination on a particular date, and that particular date was just before she turned 50. Why? Because if she received notice of termination, termination took effect once she'd attained that age, the benefits that she was going to get under redundancy were significantly more generous than if she'd been terminated just before. And so this case ultimately settled on, well, when an employer sends a letter of termination, at what point does that termination take effect? Is it the date that the letter is sent or dated, or is it when the individual receives it? And you'll see from the slide that the outcome was that it time runs from the date that the employee receives it and has had an opportunity to read it. So if you've got a letter of termination and you are sending that to an individual, and you are expecting them to have picked it up, if they're on holiday and they haven't had a reasonable opportunity to view that, it may be that that termination doesn't take effect for a few days later. Or if you send a letter to them and by recorded delivery and they don't accept delivery and it goes back to the post office, again, this could become a problem. Why is it relevant for you? Well, the contract terms in terms of notice for teachers is typically that they have to resign, or you have to issue termination by a particular date. And a good example is that if you were wanting to termination of employment to take effect by the 31st of August, you would have had to issue that notice before the end of May. If you missed that deadline, so that was only received by the 2nd or 3rd of June, for example, then the effect of the typical notice provisions in this, for teachers would mean that the notice would actually expire at the end of next term, which is the end of the autumn term, and therefore you would effectively be paying 4 months extra pay of September, October, November and December, which you can see is a huge extra cost. So the way your notice provisions typically work mean that it's really important that you hit those deadlines, and therefore really important that you've got that clarity that somebody will receive that notice of termination in good time in order for them not to be impacted by this. Now, this case says that this principle is implied into all contracts of employment. So the way to avoid this, well, there's two ways. One is you send notice of termination very clear of any sort of key deadline, but another way that we're recommending is that you actually have a clause in the contract which simply says how notice can be served and when they'll be deemed to receive it. And what you can do on those kind of things, for example, is say that it will be deemed to be received within 2 working days of the letter being sent, and that from a contractual point of view is fine. So as you're updating templates, it's things like that we'd look at, and you can see there's an immediate cost saving potentially in certain cases. A couple of points which are more operational but relevant to what I'm talking about, so I'm just going to mention them quickly. is that the way in which you calculate holiday pay for people whose pay varies has changed. It used to be you look at the pay that they received in the preceding 12 weeks. Now you have to look at 52 weeks. Make sure your payroll is on top of that and has adjusted calculations, because otherwise you'll be facing unlawful deduction from wages claims, which you wouldn't want to be. I'm doing quite a lot of work at the moment in terms of holiday. Generally, and that's arising out of COVID, because people are saying that they're unable to take their holidays. And you might be aware that the government have extended the basis on which holidays can carry over into the next year. Now, for you in education, what you absolutely don't want is people having bags of holiday that they can't take within the school closure periods, and having to eat into term time, because most contracts would require that you are available during the school open periods, and you need necessary support in that time, and that any holidays need to be taken in the school closure period. Now, there's a few things around that, and one of which is that you can issue notice to ensure that people take leave at certain times of the year, but it helps you massively if holiday is properly dealt with in a contract. And a few things on here I just want to touch on. I don't want to go into too much detail, but things like teachers' contracts, certainly if it just refers to the Burgundy book, for a starter, wouldn't be sufficiently compliant with Section 1 statements. It needs to be more detailed in the contract of employment. And quite often I still do see reference to holidays just being dealt with as per Burgundy book. That's not acceptable. Burgundy book doesn't give sufficient information. It was written 20 odd years ago, and more to the point, that there's some things that need to be dealt with within the actual contract itself for compliance. But also, it's generally understood and complied with that teachers will have the basic holiday entitlement and then some additional paid leave. But I think it's really important that you as the employers understand when paid leave is being taken, when holiday is being taken. You don't want to get into a position where there's a bit of misunderstanding there, not least because if somebody goes on long-term sick, they continue to they can't take their holiday. So if they're off sick for the latter part of an academic year and haven't actually taken their statutory holiday, they're entitled to carry that over into the next year, which is something you wouldn't necessarily want. More particularly, you wouldn't want it if actually they had the benefit of October half term, the Christmas, and really you thought that would be dealt with as holiday, but they didn't deem it to be dealt with as holiday and thought they'd be booking their leave at a different time in the year. And actually also what I see is teachers don't book leave and don't feel the need to book leave and aren't required to book the leave, because it's just generally understood that at some point within the academic year they'll take their statutory holiday entitlement and then the rest will be picked up as paid leave, so it doesn't matter. And I fully understand that, but there are some points in some case law coming out which mean that to get complete clarity and to protect the trust from some of the issues that can arise, it is better to deal with it in contract. And one of those is to ensure that there's some provision about when it is deemed that statutory holiday that they're entitled to will be taken, and also some provision in relation to the accrual of holiday in the first year and the second year, because of course if you start partway through a year, then the holiday that you're entitled to should be prorated down. So that's just one point to flag in relation to holiday, and it's just a matter of a couple of clauses in a contract, but something we would strongly recommend you do. Most schools engage term time staff and term time only staff, and here it's particularly the support staff that tend to be on these contracts. There was a significant case over the last couple of years. It's been litigated, but the last position came out about a year ago now. And we've been waiting to see if it's going to be appealed, and we've now got confirmation it is going to be appealed, so we'll have further updates on this next year. It's really important because ultimately it means that many trusts are not paying their term time only staff properly in relation to holiday. Many trusts, just like this trust here, the Harper Trust, proratas the holiday entitlement, which is a basic 5.6 weeks, to the number of weeks that term time staff actually work. Now, this case challenged that point because the outcome was that the individual was saying that she wasn't getting her full entitlement to statutory leave, and the Court of Appeal agreed. it's a complex case, and it comes down largely to the drafting of the working time regulations. But what it does mean is that term time only staff currently are entitled to a minimum of 5.6 weeks holiday, regardless of the amount of time that they work during that term. So you could even get to the ridiculous position where somebody only does a month in an academic year, but they're still entitled to 5.6 weeks holiday. And that's because the law doesn't set out, or the statutory provision doesn't allow for a pro-ratering of that 5.6 weeks to the number of weeks worked. Any higher figure, and it is quite common that additional holiday will be given, is capable of being pro-rated. But there are letters going around from the unions at the moment asking for details of the calculations that you use to calculate term time only staff and their holiday, and therefore it is a claim exposure risk for you. Now, what we're advising trusts to do is take some advice and understand the risks and the options available to them. Some are deciding to wait and just keep a close eye on the case law and see if this decision is overturned next year. If so, we're recommending that you make some provisions so that so you understand what this potential cost is in the event that claims may be made for backdated pay. Or some trusts are just embodying this within and starting to pay, allocate more holiday to term only staff, which in turn would impact on the rate of pay that they're receiving. Okay, if you want some more information on that, we've done loads of passels and articles about that particular case when it came out, so you'll be able to access that from our website. I talked at the beginning about strategic HR not only being about making sure that you're legally compliant, but looking at your existing arrangements and making them work for you, as well as reducing cost. I just wanted to pick up on some points coming out of my work with schools, which highlights some common areas and hopefully give you some food for thought. As trusts grow into multi-academy trusts, it's really important and increasingly likely that you might have a teacher working in one school who you then want to put into another school within the trust. Now, if their contract limits their place of work to one particular school, and you no longer need that person to work in that school, that's actually a redundancy. If their contract says that their place of work is that particular school or other schools within the trust, you've got an immediate contractual right to require them to move to other places of work within that trust, and therefore would avoid potential redundancy. And what it does, not only avoiding that, it gives you the flexibility to deploy your resources as you feel fit and appropriate. So at the very least, that's one point I would just check. It's quite common in the sector to do secondments, deploying your staff out to other schools. If you do that, just a word of caution, it's not something you can deal with in your standard contracts of employment, but please do ensure that those arrangements are properly documented. There's quite a lot in there in terms of who is going to be employing that person during that time, what happens after the secondment's finished, who's picking up the costs of pay during that period, and the like. And they're very easy to put some arrangements in place by way of documentation, but important that you cover that off. The other points mentioned is flexibility in duties. I know that you know, we're limited in terms of direct time and things in terms of with teachers, but the way in which you phrase the flexibility of the duties that your staff will be required to carry out is really important, because if it's just fixed to a particular job description, if you were asking them to go outside of that, they could reasonably refuse. Now, any flexibility should always be exercised reasonably and according to the skills of the individual and the reasonable needs of the employer, but a small amendment gives you quite a lot of flexibility and is really important. And then I've just put on there TLRs, how long are they lasting for? These learning responsibility payments are very commonplace in school setting. I've come across a few restructures where they are being removed and it's not really clear on what basis they were given or for how long or what's left. You know, when somebody was given an additional responsibility, did it mean that their substantive teaching role actually went? And if you're then removing this TLR, do they still have as of right a teaching post? Because if you don't have that, then that's potentially problematic. So I just wanted to flag the need to be really clear on when you're giving the TLRs for what purpose and for how long, or is it for an indefinite period. Sick pay is a really big issue in schools. Sick pay is not only very generous in terms of the entitlement you give, but there is an ongoing problem with sickness absence, and particularly recently in the last 2 years, more even, absence due to work-related stress and long-term absence. So just to deal with that last point first, managing absence, one immediate cost saving you can do is just to ensure that you're very proactive in how you manage sickness. In my experience in employment law, the longer people are off sick, the less likely they will return or successfully return. The more they feel that they, well, the more that you let things just fester, the more likely things turn more protracted and contentious. Excuse me. If you can find a good occupational health provider and be really clear in what you're asking them to advise you on, that can really be a good cost saving, because and I'm quite often supporting clients in just checking over their occupational referrals on complex cases to make sure we're going to get the information that we particularly need in order to manage that individual case. It's really important because it'll help get cases moving and give you the information you need to understand, well, what do we need to do to get this individual back to work, or indeed, are they never going to come back? Because if so, you might be able to escalate your own processes and avoid continuing sick pay where you're never going to get that individual back to work. So proactive sickness absence is absolutely key, and that, and in turn, that means reviewing your policies and procedures in relation to that. But a couple of things other trusts that I've worked with have looked at are these other points above. There are fixed. You've got your service, which starts from when you start your employment, but under the teacher's terms, you've got fixed years of sick pay entitlement, which runs from 1st of April. And so you could have a situation where you might not start your employment till the 1st of January, but then from the 1st of April, you're deemed to be in your 2nd year of sick pay entitlement and get additional sick pay because your sick pay goes from a different year, which is a bit confusing and unnecessarily complex in my view. It also manages the sickness levels in terms of looking at the sickness levels over a fixed period instead of what is arguably better, which is a rolling 12-month period where you look back and say, well, over the last 12 calendar months, your absence has been at this level. So that's just something to think about. But the provisions in relation to the sick pay service benefits are a bit tricky and can be confusing. Also, in relation to the Green Book, if you incorporate the Green Book into your terms and conditions for your support staff, the service that they've had with prior local authorities and indeed academies will be factored into that service accrual. So you could have it that even though somebody's not worked with you for very long, by incorporating those terms, they actually benefit from quite generous sick pay terms. Now, that's an unnecessary cost because in the ordinary world of employment law, that wouldn't be the case, and your service for benefits would just follow with the amount of service whilst you've been in employment with that particular employer. So that's something that can be immediate extra cost, which could be avoided if the Green Book wasn't automatically incorporated. Now, with the Burgundy Book, I don't think that is the case, but many organisations will still honour that. So I'm just putting it out there that I don't think that is strictly necessary. I mean, what is very clear is you do, for redundancy purposes, need to incorporate that prior service for both cases, but that's because of a particular statute that says that that's a requirement. So if you didn't want to incorporate those things and that therefore have teachers at the start of entry into your service on different service levels for benefits, there's one easy way of dealing with that, and that's just not automatically incorporating Green Book and Burgundy Book. The other thing which is a recurring issue increasingly is that under the Burgundy Book, if a teacher is off sick with work-related stress, there is this provision in the Burgundy book which ultimately means that they may be entitled to an additional 6 months full pay in addition to their normal sick pay. So if they're on 100 days sick full pay anyway, and then 100 days half pay, on top of that, they may also get 6 months full pay, which is a large sum of money, in addition to which you'll be paying to cover their absence. Now, this provision, I've put the wording up there, it doesn't clearly, in my view, relate to stress, but the unions argue, and I understand why they argue it, that if stress is work-related, there's no reason why it couldn't be an injury for these purposes. And often, work-related stress would be the subject of occupational health, and if occupational health or another medical practitioner is saying that there is work-related stress, then arguably it does fall within this. Now, I've successfully challenged and pushed back on that a few times, but there is this case, it's an old case, and this isn't a point that's particularly highly litigated, but it is something that tribunals are aware of, where in this case, the tribunal did look at this point and did conclude that it could include work-related stress. Now, I hasten to add that that case was just a first instance tribunal and not binding, so it doesn't set a precedent, but I suppose it does indicate that there is something here and it's one to watch. And I would say in the last few months prior to coronavirus hitting us and taking over, we were seeing an increase in unions pushing for an additional 6 months pay in relation to staff who were on long-term sickness. Now, again, if you even took into your contracts just the basic provisions that is currently offered under the Burgundy book of, again, I'll use the same example for people with certain service, 100 days full pay and 100 days half pay, and you put that within the contract, you're still offering a broadly similar benefit to what would be expected and not going to be deterring candidates from coming forward and wanting to work for you. But you could do that in such a way that you were basically taking the best bits out of those provisions, still giving you a fair and generous package, but removing points like this and some additional costs, which I think is unnecessary and potentially crippling, arguably. On a similar point, one thing that's coming up at the moment in relation to sick pay and coronavirus is that there's some provisions in both of them where if individuals are deeming themselves not to be able to come into work because of a risk of infection within the workplace, then they can deem themselves to be entitled to full pay, and that full pay should not count towards their sick pay entitlements. Now, the scope under the Green Book is much wider than the Burgundy Book. My view on the Burgundy Book wording is summarised up there. So it requires a reasonable probability of infection through the workplace. And I know that going back into the workplace, as you'll all be having discussions at the moment, is obviously going to pose a risk of infection, but is it going to be likely that they would get infected in that way more than going to the supermarket or whatever it may be? So I don't know how easy it would be for anyone to establish that threshold, but also they'd need medical practitioners to positively advise that they shouldn't attend. I'll come on to coronavirus and those people that were saying shouldn't attend the workplace in any event. But it's just something to be aware of, because it may be that it's mentioned to you where you've got some people who aren't vulnerable, aren't recommended to be shielding, could therefore be in scope for returning, but don't want to return, and therefore are looking at ways and means that they are not required to attend and continue to receive full pay without it being treated as sick pay, and these provisions would apply. Now, again, if the contracts didn't automatically incorporate Burgundy and Green Book, this wouldn't be an issue, and you'd have more flexibility in how you deal with those situations. On an entirely different point, notice periods. It's just a practical point more than anything. The notice provisions under the Burgundy Book set out prescribed timescales under which notice should be deemed to be given. And like I indicated before, it's typically 2 months ending at the end of that term. Or in the summer terms, it's 3 months ending in the end of the term, and slightly longer provisions in relation to principals. But the only exception to that is gross misconduct. And I've had a few cases where there's been individuals who perhaps had a series of misconduct warnings culminating in a final written warning, and then there's a further act of misconduct. And then in those situations, you would be issuing notice of termination, but you'd still be bound by these very long notice periods. Or SOSR means some other substantial reason, which is another reason for dismissal in law, and often arises where there's been a complete breakdown in trust and confidence. Now, again, if you were in a position where you were finding that and following a hearing came to the conclusion someone's employment needed to terminate, in both of those instances, I'd suggest that you'd want to terminate them as soon as you were able, albeit giving them reasonable notice. And I'd just query whether reasonable notice really does need to extend to much more than that 2-month basic period and does need to be any longer. And taking the same example I did earlier, if today I was terminating someone's employment because there'd been an absolute fundamental breach of trust and confidence in relation to them, but it wasn't quite gross misconduct, I would effectively be terminating employment. Wouldn't want them within the trust environment or the school environment, but I would have to be paying them now under the standard terms until the end of December. Whereas if you put different provisions in place, and again, this is only a small amendment, but an important amendment, you could potentially avoid paying them maybe 4 months pay and just do the normal termination on the expiry of 2 months. So that's something I'm working through with a number of clients, and has a lot of common sense to it in my view, and would be worth looking at. Other things that are quite common in employment contracts generally, but less so within the teaching and support staff setting, probationary periods. Now, the new Section 1 statements actually do need to deal with whether there is a probationary period and any particular terms that apply in relation to it. So this is something you should be looking at anyway. I'd always advocate having a probationary period, and the benefits of doing that is just to assess someone's performance in those early months. It's even more beneficial if in those early months, if you realise that you've made a decision, that the wrong recruitment decision, it's not working out, but you're not then bound by these very long notice periods, because again, you've got a big cost on your hand, particularly if you really don't want that individual in the organisation. You've got to pay them just to do nothing at home. It's very common, therefore, that you can have lesser notice periods in place for probationary periods, and then once they've passed the probationary period, the longer notice periods apply. So that's something to think about. And then where you do have individuals that you don't want in the workplace because of whatever's gone on to lead to the termination of employment, it's common in other contracts to have things such as a pile-on clause, that's a pay in lieu of notice clause, so that you can effectively bring short their contract and pay them the equivalent notice that they would have received if worked, but it enables you to then move on and recruit. Garden leave is another option, which is where you effectively don't require them to come into work, but they remain employed. And those kind of things should be put in. It doesn't save you costs, but it does give you options on termination, which often is really important. And then this one's useful to know as well, that if you as an employer terminate somebody's employment due to long-term ill health, under the Burgundy book, you're required to pay them full pay, even if at that point they've exhausted their sick pay entitlement. So if I was to terminate someone's employment now for ill health capability and they were on normal teaching termination notice, I'd be looking at having to pay them full pay until the end of the year. Now, that is far exceeds what is the basic provision in law. And without going into the details of how that works, ultimately, you know, where you're already giving generous notice periods, you would ordinarily only have to pay them what they would normally be due during that period. So if they're on half pay, it'd be half pay. If they're on nil pay, it'd be nil pay. So that's something to look at as well. And again, that simple provision is only in there in many contracts because of incorporation of Burgundy book. But all of this, and I do hasten to add, isn't depriving or isn't setting out to deprive teachers of the terms that they've grown used to expecting in terms of generous sick pay benefits and decent notice periods. And to a large extent, I think they work for the sector, and most employers in the sector are comfortable with them. It's just these intricacies that I've highlighted do increase cost and could, if they weren't there, give you as employers more options and cost saving. So just moving on to the next slide. Sorry, it's been a bit slow to respond to me. There we are. Safeguarding pay is another one. Under the school teachers' terms and conditions, if you make restructures and there's alternative roles available, or you're removing TLRs, for example, if that individual moves into a role which is on a lesser pay, then they are entitled to some pay protection as a cushion for the adjustment to that differential, and that cushion is 36 months, and that's I've put in the Burgundy book there, and I'm sorry, it's actually teachers' terms and conditions, but that's a really long period. So if you're trying now to look ahead and manage a deficit budget and see the need to do some restructures for cost saving, but also for other means, you're really not going to get the benefit of those restructure cost savings until 3 years hence. And the speed in which things are changing at the moment, I'm seeing restructures happen with the aim of those savings being made in 3 years. But then by the time you've got to that point, there may be other changes that need to be made as well. So it's a problem, I think. And again, it's something that's unique to your sector. And there are other ways around it, and I know that it's custom and practice and expectation that there will be pay protection in place. But the basic provision in law is if you are changing terms and conditions and reducing pay for whatever reason, or more likely where this arises, where there is effectively redundancies and substantive changes to roles, you're under a duty as an employer to look at alternative roles, and if they are suitable alternatives, then people move into those on the terms that apply. It's perfectly acceptable for you in your discretion or even in contract to set out some kind of provision whereby there will be this cushion, but if it's discretionary, all the better. If there is some contractual provision in place, that's fine too, but I would suggest that 36 months is probably much longer than is needed. And to a large extent, it also means that people find themselves being given additional responsibilities which again comes under the teachers' terms and conditions. You're able to give them some additional responsibilities to take account of this pay protection. But where somebody maybe doesn't have that capability, or it's just not something that you want to be giving to them, then that's a problem. So that's something to look about, and I've done quite a lot of work with some clients in relation to that, arising out of some recent restructures. Now, I said at the beginning of this presentation that time doesn't really permit me to go into the details of how you would go about doing this, but I just wanted to flag Academy Trusts can set their own terms. You don't need to incorporate these collective terms, but if you do, you're going to be bound by them. Similarly, if you've got collective bargaining arrangements in place, you need to be careful because you might have continued, even though the contracts are silent, you might have continued to abide by these and almost create this implied contractual expectation that you will follow those terms. Many contracts that I see will say that you will have regard to those terms in terms of what's industry expectation, but that you're not bound to them, and that's fine, but your contract needs to make that absolutely clear. And if you have bargaining arrangements with unions and you are proposing to make changes to your core templates going forward, you'd need to keep them involved and discussing what you're proposing and why. So for new contracts, you're not proposing any changes. If you were going to make any changes to the contracts, you're not making changes to existing terms and conditions. So you can put those in place. People will accept the job on those terms, and that's relatively straightforward. If you were proposing any changes to existing contracts, it's much more problematic and difficult. And what you might have, therefore, is a decision, and it's quite common, that you will leave the existing contracts as they are, but going forward, you will look to move away from these terms and conditions that are incorporated and take the best bits, but avoid these unnecessary costs that I've just flagged, just as a highlight of some of the things that we come across routinely. Obviously then as well, you might have staff who come in under TUPE if you take in another academy, and their terms and conditions will be based on that inherited. So it is quite common that you might have staff on different terms and conditions. There is also a process that can be followed to bring all of that together, but it is complex and it's not without risk, and it's not really in scope of this talk today. But a starting point is to understand your core template, make sure it's Section 1 compliant, as I've said. Also understand where are the risks, where are the recommendations for things that you could change, and then you as a leadership group with governors to look at, well, what do we want to change and why and when, and then how do we move forward with that. And to that end, I've covered off the key points on this slide, but if you are proposing changes to existing terms and conditions, it's really important you understand what you're proposing to change and why, and the extent to which you've already got a right to do that. Now, any substantive changes wouldn't be part of an existing contract, so you'd have to go through a consultation process to get agreement, and you know, ultimately you need to take advice if you're looking to do that, and maybe that could be part of a future session. But today's session is really just to encourage you to think about, well, do we need to accept the way we've always done things, or should we do things a little bit differently, and you know, to what extent? Okay, just looking at the time then and being mindful of that, I just wanted a quick wrap up on COVID, because I know it's what everybody's talking about at the moment, and working with schools as my substantial client base, I've been very, very busy and supporting schools in the last 3 to 4 weeks in relation to the whole host of issues arising about the return to work. You've got all sorts of issues about the immediate, how we bring staff back to work, who do we bring back, what about health and safety concerns, and to a lesser point, furlough. You've then got the longer term issues of, well, what's this going to mean for us? That's particularly affecting other sectors more than education at the moment, but I would think that once we've got through this next immediate period, you may find yourself in a position where, you know, your budgets have been even more stretched as a result of this, and you therefore are looking at, well, what else can we be doing to try and pull some of that back and reduce costs? And then for the reasons I'll go on to, there's one particular area where I think we might see an increase in litigation. So very quickly then, you should all be at the moment consulting about return to work, and there's still a huge amount of debate over when it is the right time and how. And I saw today that the government are saying now that they're not going to be expecting all primary school children to return before the end of this term. They've backtracked on that. That was something that they were expecting and hoping would happen, albeit focusing initially on those early years and year 6 and year 10. But in any event, all schools will be to some extent looking at return to work of their staff and should be consulting. And the duties I just wanted to flag are to consult in good time before reopening. You've got a duty of trust and care, a duty of care to your staff. You've got a duty of trust and competence to your staff. And part of that is working with them to reassure them of the measures that you've got in place to ensure that you've taken all reasonably practicable steps to implement the guidance and avert the risk of infection. To the extent that you can, try and reach agreement with employee representatives, which for the most part would be the unions, and I do appreciate that's difficult where the unions are objecting to the government and saying that they're not happy, and I know there's some local authorities are saying that they're supporting that and are not advocating returns to school. What I'm advising is keep trying to talk, keep that dialogue going, keep communicating what measures you're putting in place and why, and the things that you've considered, and listening to any objections and seeking to overcome them. Of the 5 pivotal tests that the unions have put forward, there's 2 which really are out of your control, one of which includes track and trace, and the other one is the provision of PPE. I mean, you can provide some, but there's huge question marks over what exactly that means and the extent to which you'd have to do that and for how long. But in terms of social distancing and all those kind of things, you definitely can be looking at that and should be putting your risk assessments in place. And if you employ more than 50 people, recommendation from HSE is that should be published on your website. Ultimately, you're responsible for the final decision as an academy trust and as the employer. You need to be understanding who your staff are and what their particular circumstances are, and talking to those people who are expressing concerns. Those concerns might come out of travel arrangements, and typically risk assessments haven't even had to factor in people's travel arrangements, but now we think that you do. Where people are not in the vulnerable categories or the shielding categories, and could come into work but are concerned about public transport, you do need to factor that in. It may be that there isn't a way to overcome that, and you might decide to allow them to remain at home, working from home. But there may be other options available, including a bit of flexibility on when they need to be in work, so that they're missing the busier times, and or could get to work through other means, or a lift with somebody within their bubble, so to speak, so as to minimise impact for them. And then we've got these groups, and there's quite a lot in this, so I'm not going into loads of detail, and to a large extent I'm sure you'll be broadly familiar. But you've got your extremely vulnerable people, and your vulnerable people who are being told to shield. You've also got people who are living with those vulnerable people, and I'm seeing quite a lot of queries in relation to that group. If you're fine but you're living with vulnerable people, the recommendation, you're not actually required to shield yourself, but those people would naturally be concerned about the risk of them going out into the workplace, and would that heighten the risk for those that they care for and love. And to that extent, I'd recommend a sympathetic approach, really, but ultimately you might have to require them to come in, but just be mindful of what additional measures may need to be taken to give them that reassurance of measures taken to avert risk. Then you've got your pregnant women, and there's been quite a lot of talk recently in relation to this last category, who increasingly statistics show are potentially more vulnerable if infected than others, albeit there's also statistics showing that the virus impacts negatively more on men and obese people. So I'm aware of one education organisation who's had some conversations with unions where they were really pushing that point and saying that this shouldn't just be in relation to BAME, it should be in relation to obese and or men, which broadens it out massively. I think for the most part we're looking at these categories here and following the guidance as to who should be shielding, who shouldn't, and then who is capable of coming into the workplace. And that then takes you onto these red flags. So you might have people who are not in these categories and could in theory come back to work, but they have childcare responsibilities, or quite simply they're just worried about returning. I go back to my point of the basic duty of trust and confidence and listening and sharing what you're doing, but ultimately you need to get moving back at the time that you feel that your work environment can accommodate it, and therefore you need staff to be cooperating. So there's a few things around this, and it's a bit of a balancing act as to what options are available to you. Wherever possible, we're recommending that you agree things with staff, and that might mean a different approach for some than others. But equally, you don't want to be putting those that are volunteering to come back and return to work into a position where they're going to feel aggrieved that others haven't similarly complied. I think we've all got to respect that people have their own different individual circumstances, and whatever's put in place at the moment needs to be assessed regularly, because where we're at now may be very different come September in terms of level of risk and expectation. So try and address their concerns as much as possible, but really important, I just flag this before we close. There is this right, and it's been around for a long time, but it's not particularly highly litigated, but it may well be in due course, which is where an individual can say that they can effectively say that they feel that they're in circumstances of danger, which is serious and imminent, and because of that they don't want to come into work, or they leave the workplace. Now, typically if somebody's refusing to come into work, you might look at disciplinary action. But here, if an individual is saying that this is the reason why they're not doing that is because of these things, then they've got a right not to suffer a detriment or be dismissed. And indeed, if you go ahead and do that, they can bring a claim regardless of how long they've worked for you, and it could be automatically unfair. Now, in the circumstances we're in with the the infection rate still out there, it still arguably is a serious and imminent threat. That immediate threshold could be met by an employee. So if you've got somebody refusing to come into the workplace, I think you do need to be careful about what steps you then take to penalise or force that individual in relation to those concerns. And this goes back to what I was saying before, the need for a pragmatic approach. It's very subjective, their assessment of where they feel they're in danger. but it is based on knowledge around them. So it's not just the knowledge of what facilities you've put in place and what you're telling them about why your workplace measures are adequate, etc. It's also about what guidance is out there, and if they're hearing that risk of infection is still high and are concerned about that, then that will also be taken into account. But I go back to what I just said about the situation being quite dynamic, because as guidance changed from the British Medical Association and these other advisory groups, so too will the reasonableness of people's subjective assessment here. Now, there are things that you can do as an employer, and there will be circumstances where, notwithstanding this position, you can make steps to actually say, well, we need you back and you are expected to return to work. But there is always going to be this risk that this claim is argued, and we're advising employers where they've got to this point. And in fairness, I think most schools have been able to agree positions with their staff, either via the unions or otherwise, and reach their own conclusions as to whether they think they can safely open and if they've got the right level of staff to do that. So whereas a couple of weeks ago we were concerned this was going to be a significant risk, I'd say at the moment it's just a risk that there is bubbling and it is impacting in some respect, but it's one to be aware of definitely. And it doesn't preclude you taking action, but it does mean you need to take action with care. So to-do list, well, there's quite a lot I think you need to be thinking about. I've mentioned updating your core staff templates. They're the basic ones you would use for new recruits to make sure they're legally compliant, and at the same time have a think about, well, is there scope for improvement? Do we want to challenge the status quo, and if so, how, to what extent, and why, and when? Now, that's something that we're helping a number of schools with at the moment, and we of course be very happy to support you if you needed that support. And if you did, please don't hesitate to drop me a line. We're doing an early review, just flagging those risks, and then we can give you a quote for how much those recommendations would take to implement if you wanted us to, whenever you wanted us to. Think about your term time only contracts and just look at those provisions in terms of how you're calculating holiday pay. And then I'd certainly be looking at your holiday as well, and just making sure that between now and the end of this academic year, people are taking their leave where you're expecting them to have, so that you're not in this backlog of leave carrying over because of COVID. And if you want more advice on that, again, we've got passes on our website in relation to all of this. If and when you look at implementing restructures, I haven't gone into a lot of detail on that at all today, but for present purposes, I just wanted to flag it's perfectly legitimate in law that if you have a new role created, that could be appointed on new terms, even if it's an existing member of staff, providing it is a wholly new role and not just a slight adjustment to an existing contract. And then get advice if you are finding yourself in a tricky position with staff returning to work, and you're needing to look at alternatives, because there are some alternatives that we can explore, but it's always a matter of looking at a fact-specific case-by-case assessment and then taking a bit of a balanced risk view. Okay, so I'm going to close it there because my time is up. I can see there's been a few questions come in, and I'm more than happy to look at those and then respond.
Yeah, we can share those with you.
Yeah, okay, great. I'm more than happy to do that.
Great. Well, thanks very much for a very interesting session. A recording will be available on the website later today to watch back and share. And as Jenny mentioned, there's a short survey following the webinar, and in this you can indicate if you'd like to receive further updates and communications from Irwin Mitchell. So thanks again for joining us, and we hope to see you again very soon at another Governors for Schools webinar. Thanks, Jenny.